Hello friends and welcome to the lecture. So students, as we know that we are covering the Panchayati Raj institutions, alright? And basically these are the topics we have scheduled for the discussion under this particular series, like starting with the introduction part, thereafter the evolution of the Panchayati Raj, 73rd Amendment Act of 1992, compulsory and the voluntary provisions, PASA Act of 1996, Extension Act, finances of the Panchayati Raj, and reasons for a ineffective performance. Okay. Out of this, we have so far done with the introduction part. Since last few lectures, we have been discussing about the evolution of the Panchayati Raj, and the topics we are totally left with is the 73rd Amendment Act of 1992, compulsory and the voluntary provisions, PASA Act, finances of Panchayati Raj, and the reasons for ineffective performance. Okay, so that's the picture we have created so far altogether. So basically, we will start here from where we had left in the previous lecture. So about previous lecture, we had started the discussion over the constitutionalization, right? In which basically we had discussed the Rajiv Gandhi government steps, okay? Thereafter the VP Singh government steps, and then the Narsimha Rao, okay? Like in the Rajiv Gandhi government, what happened? Like they proposed the Amendment Act in the constitution. But what happened? That Lok Sabha approved the act, but Rajya Sabha disapproved the act. In VP Singh government, they organized a meeting with the chief ministers, discussed the thing, presented the fresh new amendment bill in the constitution in the parliament. But what happened? Like the VP Singh government was dissolved, due to which the bill could not be passed. Then the Narsimha Rao government finally presented the bill, okay, in September 1991, and the bill was the 73rd Constitutional Amendment Act 1992, which came into force on the 24th April 1993. Just ignore this. Alright, that's the picture. So that is just a little bit revision, and you can say just a little bit build up before go further in this particular series, like whatsoever we had discussed in the previous lecture. Now let's have a talk about the significance of the act. Like what was the significance of that particular act? This act has added the new part 9, okay, to the Constitution of India. This part is entitled as the Panchayats, okay, and consists of provisions from Article 243 to 243O, okay. In addition, the Act also added the new 11th schedule to the Constitution, contain the 29 functional items of the Panchayat, deals with the Article 243G, okay. Like when the bill was presented, so first thing, the new part was added, which is the part 9, okay. The new chapter was created in the constitution, and the chapter name was the Panchayat. New articles were presented, articles 243 to 243O, okay. And new functional items of the Panchayat presented in the constitution deals with the article 243G, okay. This act has given a practical shape to article 40 of the constitution. Why? Because if you remember, I had told you that article 40, which belongs to the directive principles of state policy, right? In short, we also called it as an DPSP. And we know in the DPSP there is a three divisions. Like first is the socialism, second is the Gandhian principles, and third is the liberal intellectuals. Okay, so basically the Article 40 belongs to the third category of the Gandhian principles. Okay, says that the state shall take the steps to organize the village panchayats or the local governments and endue them with such powers and authority as may be necessary to enable them functions as the unit of the self government, which means that if the village panchayat is created at the village level, but the three main powers, which are the powers of legislature, executive or administration, and the third is finance. Okay, if these three prime powers not granted to the panchayat system, then there is no meaning of creating the so-called self-government. Okay, so that's why Article 40 says that they must be empowered the such powers like the legislative powers, like the executive powers, and like the finance powers, so that they could work as the real meaning of the self-government. This article forms a part of Directive Principles of the State Policy (DPSP), as I have told you, and I had also told you that the DPSC having the three divisions: the Socialism, Gandhian, and the Liberal Intellectual, and that belong to the Gandhian principles. Let's move forward. The Act gives a constitutional status to the Panchayati Raj institutions, has brought them under the purview of the justicable part of the Constitution. Justicable part means like the constitutional status was necessary so that the provisions could be what? Could be protected and preserved. Alright, and so that the justicable thing could be happen to them as a part of the constitution. In other words, the state governments are under the constitutional obligation to adopt the new Panchayati Raj system in accordance with the provision of this act. It means that the the discretionary powers of the state legislature or the government, like whether they want to have the panchayat and not, this power was abolished. Like once the panchayat becomes the constitutional part, it means every state government is now obligated that to adopt the new Panchayati Raj system in accordance with the provisions of the Act. Consequently, neither the formation of panchayats nor the holding of elections at regular intervals depend upon the will of the state government anymore. It means that they are now obligated to form the panchayats and obligated to ensure the elections at the regular intervals. And what is the time period for the panchayat? Like once get elected, for how many years the panchayat members could serve? Total 5 years. So 5 years is the tenure. And if they get dissolved before the completion of 5 years, then from the date of dissolvement within 6 months, the fresh elections are to be organized. And now this is obligated. This is not on the discretionary of the state government. All right. Thereafter, the provisions of the Act can be grouped into two categories, like the compulsory and the voluntary. The compulsory means, by the name we could assume it, the compulsory or the mandatory or obligatory provisions of the Act have to be included in the state laws creating the new Panchayati Raj system. It means that these provisions are compulsory, mandatory, and obligatory. A state government could not exercise their discretionary powers on the things. Alright, voluntary provisions, on the other hand, may be included at the discretion of the state. It means that it's depend upon the states whether they want to do it or not. Okay. Thus, the voluntary provisions of the Act ensures the right of the states to take local factors like the geographical, political and administration and others into the consideration while adopting the new Panchayati Raj system. It means that the creation of panchayat systems at the local level is the obligatory form. Like the states are obligated to do it. But formation, powers, functions apart from the 29 compulsory functions which were mentioned in the constitution. Apart from these 29 compulsory functions, the other functions are basically depends upon the discretionary of the state government, like whether they want to let the panchayats have them or not. Okay, and this is totally depend upon the geographical conditions, political administration, socio-economic, and the other demands of the state. Okay, the act is a significant landmark in the evolution. Okay, we have started the new topic right now. We have finished the evolution. 73rd Amendment Act of 1992. Okay, so there is a one thing which let me tell you, like if we talk about year of passing for the 73rd Amendment Act, and if we talk about year of implementation, so there are two differences. We are talking about 73rd Amendment Act. Okay, so if we talk about the year of passing, so it was basically passed in the year of 1992. But when we talk about the year of implementation, then basically it was implemented in the year of 1993. So keep these three things separate from each other. Okay. So the act is a landmark in the evolution of grassroots democratic institutions in the country. Grassroots means at the okay, transfer the representative democracy into the participatory democracy. What does it mean? Just try to think. What does it mean? Let me give you a hint that it is belongs to the very same concept which we had discussed in the previous lecture. Okay, just try to think. I am going to give you the 15 seconds, then I'm going to give you the answer of it. Just apply your brain, just apply your revision, just apply the facts and figures we have discussed so far. So your time starts now. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13th, 14th, and the 15th. So the representative democracy is basically belongs to the concept of the indirect democracy, and the participatory democracy belongs to the concept of direct democracy. Like as I had told you in the previous lecture, like in the indirect democracy, the public generally not participate into the legislative and executive functions of the state machinery. Instead of the direct participation, they appoint the representatives. They elect the representatives who presents them during the legislative and the executive actions. But in the participatory democracy or the direct democracy, the people directly participate in the legislative and the executive functions. All right. So basically, the 73rd Amendment Act of 1992 was based on the principle of the transformation from the representative democracy to the participatory democracy. Okay, it is a revolutionary concept to build democracy at the grassroots levels in the country. Okay, so what are the salient features of this particular thing? The salient features of the acts are, the first is the Gram Sabha. Okay, the act provides for a Gram Sabha as the foundation of the Panchayati Raj system. It is a body consisting of persons registered in the electoral roll of the village, comprised within the area of Panchayat at the village level. So what does it mean? Like if we talk about the Panchayati Raj system, we know that the Panchayati Raj system basically having the three tier 1, tier 2, tier 3, right? Tier 1 basically the Jilla Parishad, which is at the district level. Tier 2 is basically the Panchayat Samiti, which is at the block level. And tier 3 is basically the Gram Sabha, which is at the village level. So if you look at this, you will find that the basic foundation of the Panchayat is the tier 3 or the Gram Sabha. That is at the very basic foundation. Alright. And this consists the people having names in village electoral rolls. Okay. So we could say that it is at the very basic level or at the founding level of the Panchayat. Thus, it is a village assembly consisting of all registered voters in the area of the Panchayat may exercise such powers and perform such functions at the village level as the legislature of the state determines. Okay, it means that what they will do in the terms of the legislative and the executive manner. This is basically depends upon the state government or the state legislature. All right, so that is about the Gram Sabha. Another thing the act brought is the three-tier system, which was first recommended by the Balwant Rai Mehta committee. Okay, so the act provides for the three-tier system of the Panchayati Raj in every state. That is, panchayats at the village level, intermediate level, and at the district levels. Thus, the act brings about uniformity in the structure of Panchayati Raj throughout the country. However, the state having a population not exceeding 20 lakh may not constitute panchayats at the intermediate level. Okay, so what does it mean? It means that the act provides for the three-tier system for all over the country. Okay, but there are some states which population is not as much as that they are required to maintain the panchayats at three level. Why? Because that will impact on the finances of the state government. And even that is not rationally important because the population is not as much as. Okay, so if the state is having the population below the 20 lakh may not constitute the panchayats at the intermediate level. Thereafter, election of members and the chairperson, like how the election of members and chairpersons will happen. So remember, all the members of panchayats at village, intermediate and district level shall be elected directly by the people. Okay, like the Gram Sabha, like the block Sabiti, like the district levels. all must be directly appointed by the people, elected by the people. Further, the chairperson of the panchayat at the intermediate and the district levels shall be elected indirectly by and from amongst the elected members thereof. Okay, it means that the election for the members is direct. The general people could participate and vote so that the members could be elected. But when the question comes to the chairperson, then the election is not direct. It means that the general people could not participate and vote. So basically, the elected members who got elected at the intermediate and at the district levels, they are required to do the voting within themselves and then elected the person as the chairperson. Okay. However, the chairperson of panchayat at the village level shall be elected in such manner as the state legislature determines. It means that the chairperson of a panchayat at village level, his election member is basically depends upon the state legislature. Okay, or it is a discretionary power of the state legislature. The chairperson of the panchayat and other members of panchayat elected directly or indirectly shall have the right to vote in the meetings of panchayat. Okay, but right to vote is uniformly granted for all elected chairpersons, whether the chairperson got elected directly or indirectly. Okay, the right to vote will be remain as it is. Thereafter, the reservation of seats, like how the seats will be reserved, the act provides for the reservation of the seats for scheduled castes and the scheduled tribes in every panchayat, like for SC and ST. Okay, therefore, at all the three levels, okay, at Gram Sabha, Panchayat Samiti, Jilla Parishad, okay, in proportion of their population of the total population in the panchayat area. It means that in in reservation, there is no uniformity granted. In reservation, there is no uniformity granted. Further, the state legislature shall provide for the reservation of offices of chairperson in the panchayat at the village or any other levels for the SCs and the ST. It means that the SC/ST reservation is not only up to the members, not only up to the members, but also on the chairperson levels. Okay. Thereafter, the Act provides for the reservation of not less than one third of the total number of seats for women. It means that suppose if the seats are 25, sorry, 75 seats are there, for example, so at least 25 seats must be reserved for the women, including the number of seats reserved for women belonging to the SCs and the STs. Like When we talk about the women, then there will be no separate reservation for the general caste and SC and STs. There would be no separation. But in these 25 seats, all caste women will be included. Okay. Thereafter, further, not less than one third of the total number of offices of chairpersons in the panchayat at each level shall be reserved for women. So, how much reservation is allowed? One third reservation. Okay, remember this thing. The act also authorizes the legislature of a state to make any provision for reservation of seats in any panchayat or offices of chairperson in the panchayat at any level in favor of backward classes. Okay, so it is also depend upon the discretionary powers of the state government or the state legislature, because that is not a order, but that's a authorization. All right. Okay. Thereafter, the reservation of seats as well as the reservation of offices of the chairpersons in the panchayat for the scheduled caste and scheduled tribes shall cease to have effect after the expiration of the specified period in Article 334, which is presently 70 years, that is till 2020. Okay, basically, this is an old data. All right, it means that like whatever the reservation the state legislature will make for chairpersons, for women, for anything, that will be expired after the specified period. It means that that is not for the eternity. Okay, that is only for some specific period of time. Thereafter, the another thing which we could see here, it must be noted here that the above provision relating to the reservation of seats in the panchayat, both the members and the chairperson, for the scheduled caste is not applicable to the state of Arunachal Pradesh. Okay, it means that the state of Arunachal Pradesh, the state legislature of Arunachal Pradesh is exempted from the provision. This is because the state is inhabited fully by the indigenous tribal people and there are no scheduled castes. It means that the indigenous tribal people inhabited the state, so there is no need for the separate reservation for scheduled caste. This provision was added later by the 83rd Constitutional Amendment Act of 2000. So what we have got here, we have got three things. The first is that the Arunachal Pradesh is the state where no provision of reservation for scheduled caste on the members and on the chairperson is applicable. First thing we have discussed. Second thing, like what is the reason behind it? The indigenous tribal people inhabited the state, so there is no need for the scheduled caste. Okay, the provision was later added by the 83rd Constitutional Amendment Act of 2000. So which act added the provision? Constitutional Amendment Act of 2000. Okay, so students, basically in this lecture we have covered till here. In the next lecture we will continue from here. Till then, just revise all the facts and figures we have discussed in this lecture. Be ready for the another lecture. With this note, let's end this lecture and thank you.